Advisory Opinions is presented by Burford Capital, the leading finance firm focused on law.
You ready?
I was born ready.
Welcome to Advisory Opinions. I'm Sarah Isgur. That's David French. And all of those other amazing human beings are here for the FIRE Student Conference, the Foundation for Individual Rights and Expression at the National Constitution Center. And David, I would be remiss if I did not mention that we are sitting right in front of the text of the First Amendment that was brought here on these really cool trucks from the DC Museum a couple years ago. In fact, the unveiling of this happened the day of the Dobbs leak.
The day of the Dobbs leak?
Yes, because I was here for the unveiling, and I went to go get my cheesesteak, and they just handed me the most delicious, gooey, whiz cheesesteak, and my phone started blowing up. And if you remember when it first hit, we didn't know if it was a legit opinion or whatever. And I talked to husband of the pod, and he said the footnotes are correctly formatted. And I hopped in my car and went 95 down 95. Yeah, so it was all, but it's so beautiful. It brings me a lot of joy to be right here.
Well, and actually, we were destined to be here at this moment. So I'm former FIRE. We're at the FIRE Student Conference. We love FIRE, and we're in front of the First Amendment. And we probably talk about the First Amendment more than all the others combined, maybe?
It's certainly our plurality amendment.
Yeah, absolutely.
Will you say a little bit about your FIRE time?
Yeah, so I think this is right. So nobody fact check me at FIRE on this, but I'm pretty sure this is right. I was the first member of the FIRE Legal Network. This was a network of volunteer lawyers who filed lawsuits, mainly speech code lawsuits. I filed the first ever speech code lawsuit in the FIRE Anti-Speech Code Litigation Initiative, and then became FIRE president in 2004. And lived here in Philly, right down the road in Chestnut Street for a while. And then continued to be a part of the FIRE Legal Network after I left the presidency of FIRE. And so I have FIRE DNA in my veins, I think.
There are 13 tables here worth of students, though. Did you have anything like that?
No. FIRE back in the day, I'm not going to cause everyone to immediately tune out with my back in the day FIRE stories where we defended in the First Amendment, walking uphill 2 miles both directions in the driving snow. No, we were a small organization. We were a very small organization. And one of the things that you guys might find really interesting, especially since university issues absolutely dominate the news. If you're going to open up the front page of the New York Times on any given day, you're going to see stories about Harvard, about Columbia, about Chicago, about other universities. Cable news constantly talking about issues and speech on universities. When I started at FIRE, in many ways, a lot of the problems of free speech on universities were worse than they are now from a legal perspective. There were more speech codes, for example. The law on college campuses protecting student speech wasn't nearly as well developed as it is now. And we had to fight for media coverage. The media did not care what was happening on college campuses, which sounds really weird now because the media can't get enough. But we had to fight for coverage. I will never forget the first time that FIRE was mentioned in the New York Times. The reporter who wrote the story was my friend Patrick Healy, who later became my boss at the Times. And I will never forget this moment. We were at the FIRE offices. I knew the Times report was about to come out. We called a meeting of our very small staff, and I said, watch this. Because the Times has covered FIRE, we're going to hear from at least 2 networks today. And it was true. We heard from ABC and CBS on that day, wanting to know more about FIRE. That's the way things were. We were fighting to make the American public aware of what was happening on college campuses. It was a big part of what we did. And now the American public is incredibly aware, thanks in no small part to 20 plus years of effort at FIRE.
If you build it, they will come.
They will cover. Yes.
Okay, we have 3 First Amendment topics to cover with you today. 1, question of whether the IRS just pulled a sue and settle, or was this just a settle? 2, we have a pronoun case out of the 11th Circuit, definitely speechy speech, but is it government speech? And last, campaign finance reform. A cert petition was granted that we saved just to talk about with you guys, and I have a 2-hour rant on Citizens United. So get comfy, you're gonna be here for a while.
Why does the United States pay higher drug prices than other countries? Because America's the only country in the world where 340B hospitals mark up drug prices and PBM middlemen charge billions in hidden fees. Meanwhile, Americans subsidize the research and development for new cures. Other countries benefit, but don't pay their fair share. Crack down on the middlemen. End the free riding. Lower drug prices. Go to balancethescales.org to learn more. Paid for by Pharma.
The spirit of innovation is deeply ingrained in America, and Google is helping Americans innovate in ways both big and small. Central Texas Regional Mobility Authority is using Google AI to create smarter tolling systems and improve traffic flow for Texans. This is a new era of American innovation. Find out more at g.co/American Innovation.
David, let's start with the IRS case. Plaintiffs sued the IRS and asked a federal court in Texas to rule that all nonprofits were free to endorse candidates to their members. Instead, they have agreed to a settlement with the IRS. Churches and other houses of worship can endorse political candidates to their congregation. The agency said that if a house of worship endorsed a candidate to its congregants, the IRS would view that not as campaigning, but as a private matter, like, quote, a family discussion concerning candidates. Thus, communications from a house of worship to its congregation in connection with religious services through its usual channels of communication on matters of faith do not run afoul of the Johnson Amendment as properly interpreted. End quote. So, David, we've talked about these sue and settle problems in the past where a friendly organization to an administration sues that administration so that they can come up with a court-sanctioned settlement, basically, and get what they could not get through legislation, or often in a much faster way than they could have gotten it through the regulatory process. You know, you don't have to do notice and comment for a settlement. But which one is this? Is this the sue and settle stuff that I find really discomforting? Or is this actually just the correct outcome and we saved taxpayer dollars by not going to trial?
So I have mixed feelings about this because my longstanding thought has been that the prohibition against 501c3s endorsing political candidates is constitutionally problematic. That this idea that you cannot engage in some of the most core protected speech in constitutional life if you choose to accept the benefit of the tax exemption, that strikes me as a pretty severe, potentially unconstitutional condition on this government benefit. Now, so I've long had that view. However, what troubles me about this, I do not like sue and settle, as you said, which it's hard to overstate sort of how corrupt that can be because we have very precise procedures for enacting new regulations. You have to go through bicameral legislature to enact a new statute. You have to go through notice and comment rulemaking for new regulation. But if I sue the administration likes my position, they can just enter into a binding settlement agreement with no political oversight at all. That's a big problem. But the thing that is very interesting to me about this, Sarah, is how much it singles out the houses of worship. Now, I do not think it would be constitutional for the federal government to say, amongst all the 501c3s, nobody can endorse a candidate except a church.
Well, that's what they just said.
That strikes me. I think That's a fascinating settlement that I think is subject to constitutional collateral attack, because the first time you have a non-House of Worship endorsing a candidate and running afoul of the IRS, you've got a problem there, I think, if you're the IRS.
Is this one of those Satanist flags? You know how like every time someone like has a religious, a menorah or a Christmas tree or whatever, the Satanists come and are like, where can we put our Methuselah or whatever it's called?
Baphomet.
Sure.
Yeah, get up on your Satanism, Sarah.
Like, is this that where like the Church of Satan or whatever can now?
Well, that would be a house of worship,
Yeah, okay,
maybe?
the secular center for Satan.
Yeah, right. It's very ripe for somebody who is not in a house of worship, not a religious institution, to challenge, to engage in the speech, perhaps have the IRS come down on them. And I just don't see a logic in houses of worship having a preferential free speech treatment.
All right. Next up, this is an 11th Circuit decision written, of course, by friend of the pod, Judge Kevin Newsom. And by the way, like, this is always coincidental that we end up talking about his cases. We go read an interesting case, then I see it's from the 11th Circuit, then I see he wrote it. It's not like I have some Google alert for Kevin Newsom definitely said on my... I don't, though, actually, but maybe I should now that I'm saying this out loud. All right, Florida enacted a statute declaring that it is, quote, false to associate to a person a pronoun that does not correspond to such person's sex. To enforce its view of what speech is correct and permissible, Florida prohibited public school teachers, employees, and contractors from providing to a student, quote, his or her preferred personal title or pronouns if such preferred personal title or pronouns do not correspond to that person's sex. Statutory citation. A teacher who violates this prohibition faces revocation or suspension of his or her educator's certificate or other penalties provided by law. This was a 2-1 decision. And here's Judge Newsom's take on that. To resolve the private citizen government employee tension, we employ a 2-step framework grounded in the Supreme Court's decision in Pickering v. Board of Education and Garcetti v. Ceballos. David, we've called this, everyone calls this the Pickering-Garcetti test, right? Step 1, the employee must show that in expressing herself, she is or was speaking as a citizen rather than in her capacity as a government employee. The majority of the panel found that using your pronouns in class, or, Miss Wood, writing that on the board was government speech and clearly part of the job responsibilities of the teacher and not in her capacity as a private citizen. David, you agree with this outcome?
Well, I agreed with the outcome, but I don't agree. Well, let me put it this way.
You hate Garcetti. I
hate
that.
Garcetti, but under Garcetti, I agree with this outcome. So to make it, just make this as simple as possible, basically what Garcetti is saying is that if you're a public employee and your speech is part of your job, the speech you're engaging in is part of your job, it is not constitutionally protected. If it is not part of your job and you're a public employee, then if you're speaking on a matter of public concern, you're going to have some constitutional protections lock in. But this is, I think, a distinction that is ultimately extremely difficult to work with conceptually, especially in the edge cases. And the other thing is it is extremely and unnecessarily speech prohibitive for public employees, especially public employees in the educational context, which is one of the reasons why Garcetti left it completely open whether it even applied in the areas of teaching and scholarship. And my point of view is that Garcetti should not apply, period. And if it does apply, it should clearly carve out teaching and scholarship. This is not an area where we want educators to essentially be state-run wind-up dolls, where you wind up the teacher with the curriculum, and then you just put them in the classroom, and out comes the state-approved speech. No. That was never the environment that I grew up in as a student, even as a younger student. I understood that teachers had their own opinions and their own thoughts, and learning how to deal with that and navigate that, and an authority figure was part of the educational process. I'm a big believer in what Justice Brennan said in the Pico case. It's something I talk about all the time, that one of the purposes of education in the United States is to prepare students for the contentious and pluralistic society that they live in, to protect them from that pluralism by turning all of these teachers that they have into state-controlled speech automatons that in one state is going to use preferred pronouns and another state is going to be prohibited to use preferred pronouns or whatever. To me, that is a real problem I have with Garcetti. So I hate Garcetti, but if Garcetti is still good law and it has been applied broadly to secondary school education, it's been applied to high school teachers, middle school teachers, to where their speech is not protected, then I think it's the right decision just under the precedent. But while we were walking here, you made me doubt myself on that because you're not so sure that this is public speech, that this might be private speech.
This is an AO first, but I think I might disagree with Judge Newsom for the first time in AO history. Now, there's times where I don't understand Judge Newsom and what he's, some of his opinions are so brilliantly smart that I struggle. But no, this one's pretty simple. And I take his point that when you are a teacher in a classroom and you're writing your name on the board, that's clearly part of your job. For instance, if you write Miss Wood on the board, who, by the way, I'm using my calculus teacher in high school. Sorry, Miss Wood. You write Miss Wood on the board, and a student says, hey, Miss Boo-Boo Butt, I think, your math is wrong. You can punish the student for that. So it's clearly part of your job, not only to write your name on the board, but to sort of enforce decorum based on your name. Pronouns could certainly be a part of that. So I take that point, and that's his point, and whatever. But doesn't it feel a little bit odd that there is nothing that is personal speech in a classroom the whole time? You can't just walk out of your classroom if you have explosive diarrhea all of a sudden. You have to say something to the students like, hey, I've got explosive diarrhea and I need to go to the bathroom. I'll be right back in 5 minutes. That's not personal speech. That's government speech because it's part of your job that you have to say something to your students before you just dash out of the room holding your boo-boo butt. This is all coming from a book called The Book with No Pictures.
I wonder how you can tell that Sarah has 2 toddler-age boys.
It strikes me that Garcetti doesn't quite cover this, I guess, to me. And the dissent touches on this a little, but yeah, I guess this is almost more of an intuitive thing. If we're dividing the world into government speech and personal speech, I think it's too simple to say, you're on the clock, you're doing your job, everything you're saying is government speech. Now, we've seen this in the prayer stuff, that a teacher during her lunch break, for instance, can certainly say a prayer at her desk just because you're on your employer's property. And during work hours does not transform everything into government speech. The Kennedy versus Bremerton, that was a prayer by the coach on the 50-yard line right after he had finished coaching. Obviously, it was on school property. It was still within his coaching time frame, kind of, but they said that was private speech. This is not that, but it's not quite, explaining the motifs of Moby Dick either.
It's not, and that's, again, one of the reasons why I find Garcetti to be so difficult, to the point of unworkability. Because we all know, and I'm not a believer in bring your whole self to work, whatever that means, but there are...
Do you bring your whole self to work?
No. No, I don't bring my whole self to work. I have never worn my Dungeons and Dragons Converse Chuck Taylors in the New York Times building. So the moment I do that is the moment I'm bringing my whole self to work. That's right. But I'm not a believer in all of that. But we're human beings at work. And human beings at work have a combination of personal and professional conversations on a rolling basis all day long. And you better believe that includes teachers and students. Especially students are, you guys are young enough to remember your younger selves, and a lot of you guys were probably endlessly curious about your teachers. What did you think about this? What do you think about that? Tell me about your family. Tell me about...
Did you always have that teacher that everyone would say, like, was drunk at school? Like, there was vodka in the water bottle, and like every time she went to go pour some of her water bottle into the plant, it was vodka? Because we definitely had that rumor about a teacher, which now as an adult, understanding how hard it is to keep any plants alive, she was not pouring vodka into that plant. That makes no sense. There was also no evidence whatsoever that she was drunk.
I can't say that we had that conspiracy theory, but we had many about our teachers, and it's just artificial. I think the difference between with the Pickering test is the Pickering test actually has a test that's much more workable in real life. Is something a matter of public concern or not is a lot easier to adjudicate than whether something is personal or not, especially when all of the speech that could be personal or not personal is taking place in a professional setting. I just think it's unworkable, but I think according to the definitions of professional speech that we have now, I think Judge Newsom is right, although I wish he would have concurred with himself to then say, Garcetti is not workable, Supreme Court. Let's do something better than that.
And we'll take a quick break to hear from our sponsors over at FIRE. Free speech on campus is under attack, and professors are too often among the first to draw administrators or their institutions' attention. FIRE, the Foundation for Individual Rights and Expression, defends faculty when universities try to silence or punish them for their views. FIRE's Faculty Legal Defense Fund connects threatened professors with attorneys ready to fight for academic freedom and the First Amendment. FIRE is expanding their national network of lawyers who believe that the right to think, speak, and teach freely is worth fighting for. If you're a lawyer who's ready to fight for free speech on campus, visit thefire.org/network. That's thefire.org/network. Protecting academic freedom has never been more important, and it can't happen without principled defenders like you.
Hey, it's Ryan Reynolds here from Mint Mobile. Now, I was looking for fun ways to tell you that Mint's offer of unlimited premium wireless for $15 a month is back. So I thought it would be fun if we made $15 bills. But it turns out that's very illegal. So there goes my big idea for the commercial. Give it a try at mintmobile.com/switch.
Upfront payment of $45 for 3-month plan, equivalent to $15 per month required. New customer offer for first 3 months only. Speed slow after 35 gigabytes if network's busy. Taxes and fees extra. See mintmobile.com.
Have you ever been searching about what to do on that really weird toe fungus you have? In incognito mode, of course. But did you know that incognito mode is not enough unless you use ExpressVPN? Without ExpressVPN, these third parties can still see every website you visit, even in incognito mode. Your internet service provider, your mobile network provider, the administrators of your Wi-Fi network. ExpressVPN reroutes 100% of your traffic through secure encrypted servers so third parties can't see your browsing history. Why is ExpressVPN the best VPN? They hide your IP address, making it extremely difficult for third parties to track your online activity. It's easy to use. Fire up the app and click one button to get protected. It works on all devices, phones, laptops, tablets, and more, so you can stay private on the go. Protect your online privacy today by visiting expressvpn.com/advisory. That's expressvpn.com/advisory. And you can get an extra 4 months free. expressvpn.com/advisory. All right, well, finally, we get to my favorite, the campaign finance section. There was a CERT grant, David. There was a CERT grant. We haven't got to talk about it yet. Also, the lower court opinion was an en banc decision by the Sixth Circuit with the majority opinion written by Judge Sutton. And as we talk about this, as I was sort of marinating in how we were gonna walk through this today, it really was striking me that I don't think there's much debate at this point that Judge Sutton is sort of the powerhouse judge in the country who's not on the Supreme Court.
The 10th justice.
Yeah. So it was an en banc Sixth Circuit decision written by him as chief. It was actually, there was only one dissenting opinion, Judge Radler, who's also a friend of the pod, though Judge Thapar wrote a concurring opinion that is also kind of a dissenting opinion. You, in particular, are going to not like that, the par concurring opinion, because it was just taking to task the tiers of scrutiny when it comes to the First Amendment. So anyone who's into tiers of scrutiny versus text history and tradition as applied to the First Amendment, something Judge Newsom has written about as well, that the par concurring opinion is good times, but not what we're talking about much, at least today. I am going to walk you guys through the painful history of campaign finance in the United States. So hold on to your hats. It's going to be an exciting journey. Starting, David.
I was just going to say, and I would note, if you are thinking, oh my gosh, I'm at a fire student conference and we're about to talk about Citizens United.
No, I'm at a fire student conference and we're about to talk about Citizens United.
I know that should be, and I'm going to say that's why that should be your idea and your attitude, because what we're talking about is a complex labyrinth of case law around the most core speech in the United, like core protected speech. Whatever argument people have about the meaning of the First Amendment, they're pretty unanimous that the First Amendment was intended to protect political speech. And we're about to walk through all the ways in which the Supreme Court has held that the First Amendment doesn't protect political speech in certain contexts. But go ahead.
1972, the Federal Election Campaign Act is passed. There's two ways of looking at this piece of legislation. One way is that this is a piece of progressive legislation from folks in Congress who were getting a lot of pressure to get big money out of politics, the corrupting influence of America's wealthiest citizens, paying for legislators. I want to give you an alternative way of thinking about FECA, which is through the lens of incumbent protection. Because which is more likely, that all of those guys who were already in Congress wanted to stop the way that they got there, or that they wanted to make sure that they got to stay there? Which sounds more like Congress to you? Campaign finance laws are passed by members of Congress, almost all of whom will be running for re-election. It would be very strange if these laws in any way helped their opponents. And of course, they don't. Incumbents benefit enormously from fundraising limits because they already have a ready-to-tap donor list. Basically, incumbents start from the 50-yard line for each election, but when Mr. Smith wants to go to Washington, he has to invest a staggering amount of time to raise money in those $3,000 now-ish chunks. It's actually $3,500 right now. Time that would otherwise be spent meeting with voters, getting his name out there. It's why incumbents most fear self-financing opponents. Incumbents' biggest advantage, time and money, both instantly disappear if they have a self-funding opponent. Okay, so that's 1972. That's FECA. It's going to set up the structure that you know today, roughly. 1976, Buckley v. Vallejo. The Supreme Court held that the ceilings on individual campaign contributions do not violate the free speech guarantees of the First Amendment because they safeguard the electoral process from corruption and the appearance of corruption. At the same time, the court ruled that when individuals and organizations spend money to voice their own political opinions, the First Amendment protects that right, prompting the court to invalidate the Act's limits on independent expenditures. This is all going to be very relevant, so I hope you memorized what I just said. Buckley, by the way, was 6 opinions, 5 of which were partial dissents. The majority was a per curiam. It is a total and complete mess, and yet it is the Supreme Court foundation for everything else we're about to talk about. Buckley! Okay. 2001. And this is the case that's going to be at issue in the cert petition. This is the case they're deciding whether to overturn. FEC versus Colorado GOP Federal Fund. It's a 5-4 decision written by Justice Souter. There's actually, we call it Colorado 2. There's a Colorado 1. Don't worry about it for our purposes. Colorado 2 in 2001. Independent expenditures can't be limited, but coordinated money can be. The court worried that donors and candidates could sidestep the contribution limits that Buckley allowed, prompting the court to hold that, quote, a party's coordinated expenditures, unlike expenditures truly independent, may be restricted to minimize circumvention of contribution limits. So this is the idea that a political party can spend whatever money it wants about a candidate on its own. But that political party cannot call the candidate and ask, hey, what's your message? What are you going to run on? We were thinking of running an ad on puppies. Do you like puppies? That's a coordinated expenditure. And there's limits on that. So the current limits, you can give a candidate $3,500. You can give a state party $10,000. And you can give a federal party committee, that includes we'll just do the Republican side for sake of my background, the National Republican Congressional Committee, the National Republican Senatorial Committee, and the Republican National Committee, and obviously the Democratic counterparts, $44,300 as of this cycle. So the problem would be that if we allow the parties, if you can only give the candidate $3,500, but you can give the federal party $44,000, and that federal party can take the $44,000 and ask the candidate how they want you to spend it, didn't we just raise the individual contribution limits to individual candidates to roughly $48,000? Okay, 2 more cases I need to run through before we get to this one. 2014, McCutcheon. Overall limits to how many candidates you can give to. So before you could, all those limitations I said were like good, but then there was an overall, I think it was $120,000 limit that you could give per cycle. The Supreme Court struck that down in 2014 in this McCutcheon case. Disclosure, I was at the RNC, I was very involved in that case. While the First Amendment allows restrictions on direct contributions, it does not allow Congress to layer on top additional restrictions, ostensibly to prevent circumvention of the base limits. And the court strengthened the closely drawn test, emphasizing that this rigorous test demands narrow tailoring. So, basically, you can have one prophylactic against the appearance of quid pro quo corruption, but you don't put a condom on top of a condom. It doesn't work, and it's not comfortable, I've heard. Okay, 2022. This is the Cruz case. This was decided quite recently. This was a setup case, frankly, about a limitation on when a candidate loans their campaign money, whether the campaign can pay that money back to the candidate after they've won the election, and how much. And the Supreme Court struck down the limitation. The courts said that the government must show that a given campaign finance restriction will actually have a tangible effect on corruption. There was just nothing about the debt repayment that seemed like it had ever prevented corruption. Okay, so that takes us to this cert petition on whether that they've granted, on whether to overturn that FEC case, whether to get rid of the coordination limits, whether a party has a First Amendment right to coordinate its expenditures with its candidates. Now, David, we haven't talked about the elephant in the room case, and we're not going to for a second, because I want you to weigh in on this march through independent expenditure history before we do Citizens United.
So I sometimes feel a little bit embarrassed when I've been thinking about something for a very long time, and then I read one sentence that completely encapsulates the whole issue in a way that I've never thought of. Thank you, Judge Sutton. I was trying to figure out how can we concisely and clearly walk through this with students in a way that they'll kind of get a sense of what this is all about. And I love this sentence from Justice Sutton. So this is basically the how to understand campaign finance law right now. For the most part, this formulation, referring back to all the cases that Sarah talked about, has led the court to uphold contribution limits and invalidate expenditure limits. Okay, what does that mean in plain English? What that means in plain English is if I want to spend my own money to articulate a position or to support a candidate, I can do that, and I'm spending my money, and it is my speech. Let's say I want to take out a full-page ad in a newspaper, and it's me talking, and then that expenditure, my expenditure form that is my speech, is going to be protected. However, if instead I'm saying I want to give money to Sarah for Sarah to speak, and Sarah's a candidate, well, then that's a contribution, not an expenditure, and that contribution can be limited. So that feels pretty clear, but as Sarah was saying, this coordination point is where you really begin, where the rubber really meets the road on this issue. Because if I, as you were saying, if I could spend endless amounts of money, my own money for my own speech, I'm a political party, endless amounts of money for my own speech as a political party, and then I want to call Sarah and see how she wants me to spend that money, well then, as you were saying, is that really a contribution limit? No, it's not one. So then you get to this absurd spectacle that we have right now in America. We're not just in the political party versus candidate context, but also say in the super PAC and candidate context. You have all of these entities spending money for a cause that they're not allowed to talk about with the candidate. And so then it leads to this weirdness. Like, I'm sure you guys have seen this in a leaked campaign memo, the Cruz campaign or whatever, in a leaked campaign memo, the Thune campaign, whatever campaign has saying that the spending of the super PAC has been particularly unhelpful and so is that coordination? No, that's a press release, right? So you have or that's a leaked memorandum. So you have the background quotes or the leaks.
And to be clear, that is completely legal because as long as the information's public, it's not coordination. Coordination is only private communication. So this has led to also public websites that nobody knows about that are like xkdc425.com. And as long as everyone agreed beforehand that they knew about that website and then you broke off into super PAC world and campaign world, I'm exaggerating a little, but that's legal.
And I think you're going to see a theme for some of our comments. We don't love legal standards that are silly and unworkable in real life. And this is the coordination restriction is one of those that was created because of the expenditure contribution distinction that the law was making, but it demonstrates how the expenditure contribution distinction itself has problems if you have to then create this artificial barrier to human interaction to maintain it.
Okay, now we have to do Citizens United, because I bet all of you have heard of Citizens United, and I bet if I picked on any one of you to tell me what Citizens United actually was about, we would have a very high failure rate. I mean, maybe not in this room, but I kind of think even among like elite lawyers, we would have a very high failure rate. By way of background, advisory opinions used to be kind of split between law and politics. I spent close to 20 years as a political operative. We are about to enter the heartland of Sarah's operative days. I came up through a lot of this legal landscape changing. So in fact, in my law school application, David, I don't know if you know this. Do you know what I wrote my essay on?
No.
Working for Swift Boat Vets for Truth. The original 527 in the 2004 campaign.
Are you kidding me?
No. So I worked as a lawyer at the NRSC, helping set up the independent expenditure unit. I was on Romney 08 and 12 in the legal departments. And then in Carly Fiorina's world, we were pushing the boundaries of super PAC not coordination. It led to this great quote, because Carly's super PAC was capital, it was an acronym, CARLY. I forget what it stood for, because who cared? And then the campaign was Carly. So if you showed up, you wouldn't know. They basically did all of our ground game for us, and it would just say Carly in all caps, and you would think you were at a campaign event, even though you were at a super PAC event. And the Wall Street Journal did this great piece on it, where, speaking of not coordination, the head of the super PAC gave this. It's either a really great quote or a really this is why you need a comms director quote. He said, we could name it Carly for puppies. It doesn't matter. It can't break the law. Shh, don't say that. Okay, so Citizens United, decided in 2010, is a re-argued case, which is interesting because the Supreme Court hears it the first time, and I just... Let me read this transcript from the oral argument in the first argument. Chief Justice Roberts, if it's a 500-page book and at the end it says, so vote for X, the government could ban that? Malcolm Stewart, well, if it says vote for X, it would be express advocacy and it would be covered by the pre-existing Federal Election Campaign Act provisions. Chief, no, I'm talking about under the Constitution, what we've been discussing, if it's a book. Stewart, If it's a book and it is produced, again, to leave to one side the question, Chief, right, take my hypothetical. Stuart, yes, our position would be that the corporation would be required to use PAC funds rather than general treasury funds. Chief, and if they didn't, you could ban it? Stuart, if they didn't, we could prohibit the publication of the book. Just to be clear, when the government says that they can ban books under the US Constitution, you're going to have some justices who are unhappy with that. So they called for re-argument to decide whether they should overturn this case called Austin. That's pretty bad if the Supreme Court's like, that was such a terrible argument that now we're thinking of overturning the entire precedent, something we weren't going to do beforehand. When it's re-argued, the advocate for the Solicitor General's office says, we took what the court reaction to some of those hypotheticals were very seriously. We went back, we considered the matter carefully, and the government's view is that although this section does cover full-length books, that there would be quite good as-applied challenges to any attempt to apply it in that context. And I should say that the FEC has never applied it in that context. So for 60 years, a book has never been an issue. The Chief. We don't put our First Amendment rights in the hands of FEC bureaucrats. And if you say that you are not going to apply it to a book, what about a pamphlet? Oh, I think a pamphlet would be different. A pamphlet is pretty classic electioneering. So yes, we could ban a pamphlet. And by the way, do you know who argued for the Solicitor General's office in the re-argument of Citizens United? Elena Kagan. Yeah, so she backs off the book ban and then is like all in on the pamphlet ban. Okay. So let's back up to what Citizens United was really about here. Section 441B of the Bipartisan Campaign Reform Act, this is 2002, it's the update to that 1972 FECA Act, makes it a felony for all corporations, including nonprofit advocacy corporations, either to expressly advocate the election or defeat of a candidate or to broadcast electioneering communication within 30 days of a primary election and 60 days of a general election. Thus, the following acts would all be felonies under 441B. The Sierra Club runs an ad within the crucial phase of 60 days before the election that exhorts the public to disapprove of a congressman who favors logging in national forests. The National Rifle Association publishes a book urging the public to vote for the challenger because the incumbent U.S. senator supports a handgun ban. The American Civil Liberties Union creates a website telling the public to vote for a presidential candidate in light of that candidate's defense of free speech. In this case, it was a couple dudes like in their garage putting together a documentary called Hillary the Movie. I actually have this DVD at my house, David.
Wow. That's a deep cut. Yeah. How is it? Is it good?
No.
Okay.
Trying to think. Yeah, no. But it's really classic political speech. I mean, it's a documentary of people saying that they don't like Hillary Clinton. I forget if it includes the woman who says that Hillary killed her cat. Do you remember that really famous 90s story that Hillary murdered someone's cat to intimidate them from not speaking out against her or something?
Oh, Sarah, in the 90s, it wasn't just a cat the Clintons had murdered.
Well, I know, but the cat thing I think really jumped the cat for me.
I have the distinction of having received in the mail, unsolicited, the infamous at the time Clinton body count documentary about the Clintons as serial killers. So if you think you live in the exclusive age of conspiracy theories, ladies and gentlemen, you do not.
So they wanted to release this movie on demand within 60 days of the general election, of the primary election in 2008. And that would be illegal under BICRA. I mean, just right off the bat, that should strike everyone as pretty nuts that you can't release a movie because it criticizes a candidate because it criticizes a candidate? Mind blown. Okay. That is what Citizens United is about, and I feel like nobody knows that. So here's line from Citizens United opinion. The government regulate corporate political speech through disclaimer and disclosure requirements, but it may not suppress that speech altogether. The government has no anti-corruption interest in limiting independent expenditures. The appeals court ruled that contributions to groups that make only independent expenditures cannot corrupt or create the appearance of corruption. The First Amendment does not permit laws that force speakers to retain a campaign finance attorney, conduct demographic marketing research, or seek declaratory rulings before discussing the most salient political issues of our day. Here's the two big things that I hear. Well, the one big thing is that Citizens United caused super PACs and led to big money in politics. I think there's a real question to be had whether Citizens United, the actual holding that a corporation out of its general treasury funds can spend money on independent campaign speech. I challenge you to tell me a corporation that is doing that or has done it at any of the previous cycles.
I mean, the only corporations that I would think of that have done such a thing would be corporations such as news organizations that have an editorial board that endorses a candidate.
Oh, how funny that you say that.
Or a labor union that endorses a candidate. One of the things that's frustrating about talking about Citizens United is people treat it as if it's like the Exxon Enablement Act. That this is, the Supreme Court just walked in and said, well, this is how the richest companies in the world get to dominate our politics. No. It's talking about corporate speech, which a corporation absolutely includes Exxon. It includes Apple. It includes NVIDIA that just hit a $4 trillion market cap. Also includes a mom and pop grocery store. It also includes a church. It also includes a newspaper. It also includes a labor union. So the corporate form is essentially omnipresent in American life. Is the way that institutions exist in the American legal system is through a corporate form by and large. And so Citizens United is not a case that says big corporations get to run things. It is a case that says the most common way that we human beings associate in our legal system is not an impediment to your speech, is the way I interpret Citizens United.
The Red Hot Clearance event is on right now at Burlington, and I'm excited for the markdowns. It's all about savings on top of savings throughout the store. This is when I stock up on styles for my closet, home decor, and much more because there's up to 70% off other retailers' prices on clearance. I mean, I'm going every day because these prices, too hot to miss. Burlington. Deals, brands, wow. Styles and selections may vary by location.
Put us in a box. Go ahead. That just gives us something to break out of. Because the next generation 2025 GMC Terrain Elevation is raising the standard of what comes standard. As far as expectations go, why meet them when you can shatter them? What we choose to challenge, we challenge completely. We are professional grade. Visit gmc.com to learn more.
This gets to your point about unconstitutional conditions, right? Because granting someone corporate form is the government, right? The government gives you a corporate charter. And the question is, can you condition that corporate charter on not being able to advocate for a candidate? And the Supreme Court basically says no to that. But again, you don't know any corporations that are spending out of their general treasury funds except the New York Times and ABC News, et cetera. So the first thing I hear, corporations shouldn't have First Amendment rights. There's this great string cite in Citizens United. The sentence is, the court has recognized the First Amendment protections extend to corporations. And then it lists all of these cases. I'll just walk through a couple of them. New York Times versus Sullivan, that actual malice standard in defamation suits. Oh, guess what? The New York Times had to have First Amendment rights in order to have that decision, so you'd have to overturn that one. New York Times versus United States, that's the Nixon Pentagon Papers one. Oh, yep, you'd have to overturn that one. Tornillo, that was unanimous in 74, overturning a Florida state law that required newspapers to offer equal space to political candidates who wished to respond to election-related editorials. Bellotti, 78. Does the First Amendment protect the rights of corporations to attempt to influence the outcome of elections in which they have no direct monetary interest? Turner 2, that was a 5-4 in 97. Cable companies were being must-carry laws for cable companies, right? Every time the Supreme Court, of course, those companies have First Amendment rights, or else you basically have gotten rid of all media organizations.
Here's an interesting case. NAACP versus Alabama was involving Alabama's attempt to restrict in the NAACP's operations as a corporation in the state of Alabama until they would release names of all their associates and all of their members and associates, which could have been a death sentence for people.
Obviously, corporations do have First Amendment rights, or else you're going to have to overturn like a gazillion billion precedents of the Supreme Court. Number two, money isn't speech. I totally get the intuitive feeling that giving a candidate money is not your speech, and therefore it can be regulated. But let me put it in a different context. You have a right to counsel in a trial, a criminal trial. What if the government regulated that and said you can only spend $50 on your counsel? Would that violate your constitutional right to counsel? Of course it would, even though money isn't a lawyer. That's how you get the lawyer. What if they said, you have a Second Amendment right to keep and bear arms, but you can't spend more than 25 cents on that right? Obviously, that would be struck down. So, yeah, money isn't speech, but in every other context, it's so intuitive that the money, absolutely, the government can't use a restriction on the money as a way of limiting your right. Okay, so then, I told you guys that nobody's spending that corporate treasury money on speech, and you're all probably a little confused because you're like, all of these corporations are spending a ton of money, right? I'm told there's like billions of dollars of this money. That's super PACs. That has very little to do with Citizens United. Super PACs are through the Federal Election Commission. And by the way, so those are 527, same as Swift boat vets. What Citizens United said was that these independent expenditures don't have the appearance of quid pro quo corruption. There was then a DC Circuit decision called Speech Now that applied that to the 527, that if the 527 is just doing an independent expenditure, you can't have a contribution limit on what you can give to that PAC. That gives rise to super PACs. There's also 501c4s. Those are through the IRS. They are social welfare organizations. Those are even funnier. At least, with the 527 super PAC, you are still disclosing all your donors, how much money, how you're spending it. There's like endless FEC requirements. Because the 501c4s are through the IRS, not the FEC, if you're doing electioneering, you still have to file some stuff with the FEC on like how much you've spent, but you don't have to disclose your donors. 501c4s are very popular these days, but again, it's not corporations coming together to make Hillary the movie. That just didn't happen the way that people thought. But David, I wrote down my list of why Citizens United didn't matter.
Oh, why it didn't matter. I can't wait to hear this.
I wrote some on why it does matter too, but here's my why it didn't matter. One, it turns out money doesn't matter. It's not predictive of who wins at the national level. In 2016, Donald Trump spent less than pretty much every major candidate in the Republican primary, and he spent less than Hillary Clinton. In the 2018 Senate races, it was actually almost reverse predictive. The candidates that spent less in the general election were slightly more likely to win than the candidates who spent more in the 2018. I said it was a total wash of predictability. Campaign finance laws still protect incumbents. I kind of thought that Citizens United would tap away at that incumbent protection thing, but looking at the 4 election cycles before Citizens United, House had a 93% reelection rate, Senate had an 86% reelection rate, and then the cycle after Citizens United, House had a 93% reelection rate, Senate had an 86% reelection rate. Made no difference for incumbent protection, which was deeply upsetting to me.
Can I can I pause for a moment on those numbers? 93% reelection rate in the House, 86% reelection rate in the Senate, and yet Congress has the abysmal approval rating from the public. Okay? I've got a message for the public. It's on you. It's totally 100% on you at this point, because if you're saying, I don't like Congress, and yet you're constantly re-electing your incumbent congressman, guess what you're saying in the real world? I like Congress just fine. And we'll get to, hopefully over the course of the weekend, I'm also coming back tomorrow and we'll talk more broadly about sort of the constitutional realities in the United States. But as we look at problem after problem after problem with the system and the structure of our government right now, it's all coming back to us. It just all comes back to us. It is everything that we have voted for. Nothing is happening that we haven't voted for, okay? And I know that a lot of people get upset and are disillusioned about American government. Vote for different people. Like, do it. And I think that this is a constant problem in American government. You have widespread discontent with both political parties, and yet zero truly meaningful effort to break free of that trap. And so it's creating an enormous sense of discontent in the American public that is the fault of the American public.
So this is my last one. Not a single campaign operative that you will talk to like super PACs, except the ones running them who are getting paid to run a super PAC. Obviously, that's pretty good business. They're incredibly inefficient. Campaigns get a discount on ads that they buy, and super PACs don't. In 2015, Reuters found that in just over a week, the Bush campaign spent $41,000 to run 44 ads in New Hampshire, and that the super PAC spent $140,000 for 31 spots on the same show. So, I mean, these donors are throwing away about 70 cents on the dollar in some cases. To not be able to coordinate with the candidates annoys the ever-living everything out of the candidates. Oftentimes, the super PAC is kneecapping their message. It's a terrible way to run a railroad. And David, this is the punchline of the whole thing. What's the answer, right? Because if the Supreme Court has held that this is a constitutional command of the First Amendment, you could amend the Constitution to undo Citizens United, but hopefully we've shown that that will have all sorts of really perverse effects that nobody thinks would be good. Or, and just bear with me, no limits, full disclosure. It's like Texas Hold'em, but we have the technology now to have near instantaneous disclosure of donors. Texas, Virginia, Pennsylvania, like tons of states already do this, and you can complain about them, but it's not like they're these wildly corrupt governments in the no limits full disclosure states, and you get rid of all of this, the Full Employment for Campaign Finance Lawyer Act, and all of the shenanigans and the workarounds and the crazy website name so that it's public and therefore legal to coordinate. All of that just goes away, and all the super PACs, gone. And you can actually hold candidates responsible for their message and for their donors, two things that we don't do right now.
You know, I have always been confused a bit by a campaign finance regime that is dramatically restrictive of First Amendment rights, that can exist constitutionally, right alongside robust bribery statutes. So it seems to me that the robust bribery statute should be enough. That if the concern is with the amount of the contribution, that is diving straight into core protected speech. So what we are doing is we're limiting core protected speech to prevent the kind of corruption that's already prohibited by criminal law. And so I get the concerns about corruption, I really do, but that's why we have bribery statutes. So I'm with you. I'm with the no limits. I have some qualms about requiring full disclosure, especially in an environment where there is an environment of threats and intimidation, a cancel culture world. I do worry about the full disclosure.
We can certainly have something like we have now. Donations under $200 are not disclosed. And you can't just give $199. Like it's cumulative. All right, with that, Molly, can we take some questions?
Hi, my question was about the New York City financing system that they've come up with, which was very relevant in the recent New York City mayoral Democratic primary. I don't know the exact specifics, but I know that it essentially limits kind of outside spending, and it basically there's like a limit on how much a campaign can raise, and then that's like matched by like funding from the government. I was curious what you guys think about that in terms of like as a solution, if your priority is to kind of get money out of politics and sort of prioritize more campaigns that are less influenced by like big money.
My sweet summer child, we used to do that at the federal level. And Barack Obama is the first candidate who stopped taking the matching funds because he thought he could raise more money outside of it, and he did. And nobody has taken them since that I'm aware of.
That phrase, let's get money out of politics, it's a big money out of politics. We spend less on money in politics than we spend on dog food, okay? So I love my dogs, but the Constitution doesn't hinge on their behavior. The Constitution does hinge on the conduct of our political system. And so I don't have a problem with investing a lot of money into American politics, again, with the understanding that we have robust bribery statutes and we have robust means of enforcing bribery statutes, for example. But let's go to New York for a minute. I guarantee you one of the reasons why the establishment alternative to Mamdani was Andrew Cuomo was that in spite of all of the Cuomo scandals, in spite of all of the sexual harassment, alleged sexual harassment, in spite of all of the misdeeds during COVID, he still had the name Cuomo. And the name Cuomo in New York is worth a lot of money, okay? It's worth a lot. It's one of the reasons why we continue to have 2,000-year-old senators. Because over the course of 1,500 years in office, their name gets known. Okay.
Name identification is the number one predictor of candidates that get out of primaries. It's the biggest reason that Donald Trump won the 2016 GOP primary. It's the reason that you see these candidates over and over again, like running and winning, is they have name ID going in. That's what I mean by incumbent protection. Every time you're trying to get big money out of politics, you are helping the candidate who's already famous.
If you're saying, I hate Congress and let's get big money out of politics, I say pick a lane. Pick a lane. Because if you don't want big money in politics, you love this Congress. If you want reform, if you want real change, if you want to end this gerontocracy that we often have running this country, which, by the way, is pretty striking when you go and visit other countries. I was in Ukraine in 2023 covering the war, talking to senior Ukrainian government officials. And there were two things that struck me when talking to the senior Ukrainian government officials. I think when I was in the rooms with them, I was often the oldest person in the room. I was about to say, don't you say anything. I was often the oldest person in the room. And the other thing I noticed is they talked like normal people. They didn't talk in like the consultants speak and the talking points and all of that. So one thing I wanted to impress upon people, if you're saying get big money out of politics, one of the things you are saying subliminally with it is let's maintain the status quo. And if you're good with that, I'm going to disagree with you, but at least just let's be clear about what this is.
First of all, thank you so much for agreeing to talk. I guess I had one point about the money doesn't matter election. And I guess you can look at it in a broad aspect and say, yeah, incumbency rates haven't really changed before and after. But when looking at like particular cases, for example, Jamal Bowman versus Whitmer in the primaries, as well as Latimer, not Whitmer, forgive me, and Bush against Bosley Bell, it felt very much so that money did in fact kind of push the race by running campaigns about like for example, the fire alarm ringing. How can we reckon with the fact that money doesn't really matter while also simultaneously shifting some races very dramatically?
Money absolutely affects down ballot races where name ID is low. The money is for the name ID every time. If you're a political operative, it is all you're doing, all of those ads, everything at down ballot races. Name ID, name ID, name ID. So money does matter down ballot, but statewide Senate race, national presidential race, that's where the money is no longer predictive. It used to be, by the way. I could tell you who would win by how much money they raised. It's why it used to be such a big news story when your FEC reports would come out. But that's changed. Basically, there's an amount that is sufficient, and everything over that amount is just diminishing returns, and at some point, negative returns. There are, not to pick on the Right to Rise folks, that was Jeb's super PAC. Jeb, exclamation point. I think they actually were lighting money on fire to stay warm in the winter. Like there was nothing for them to do with the money at some point. Well, at that point, the money is just not going to be predictive and it's not going to matter.
Thank you for speaking. You guys were actually my number 2 on Spotify Rap last year, so I really enjoy your podcast. My question is that I think most people would say that the Roberts Court has generally been very protective of the First Amendment. However, I think from FIRE's perspective and some very much pro-free speech perspectives, this term was less so with the TikTok decision, with the Paxton decision, with the denial of writ when it came to the 2-gender shirt, with the Paul Clement case about abortion limit zones. And I'd also say, I think some people would say, are there concerns about, and I guess you referenced it with Judge Thapar, how will text, history, and tradition potentially replace tiers of scrutiny, and what will the impact of that be on a lot of these judge-made First Amendment precedents going back to Holmes and Brandeis, which really aren't based upon originalism. I think even Robert Bork in the 70s argued First Amendment really, from an original perspective, only protects political speech. So I guess with those two in mind, what do you think the future of the First Amendment could look like?
I'm so glad you asked about the TikTok and the Paxton case, because I would say that this is maybe the only time in advisory opinions history that one or both of us has disagreed with the FIRE position on those cases. And I think one of the differences is that in both TikTok and in Paxton, the question is, whose speech is truly being implicated here? And in my position in both TikTok and Paxton was that the core issue here involved speech that, or involved speech that, or access to information that was not constitutionally protected. So at the core of TikTok was, does the People's Republic of China, operating through this corporate form, have a right to participate in the American public square? And my answer to that was a hard no. Okay, even if a lot of Americans had an incidental burden on their First Amendment rights because they had chosen by mistake TikTok to use as their primary personal platform rather than all these other social media outlets that are not owned by or governed by the People's Republic of China. In my view, that's on you. If you've chosen to put your personal brand and your personal speech amongst the menu of sites that are available, all of whom in this menu have vast potential audiences that you can reach. You chose the one run by the People's Republic of China. There's like a moral hazard there. And so the core issue in TikTok did not involve an entity, China and TikTok, that didn't possess First Amendment rights, but did have, as the legislature found, very negative effects on American national security. So I think that the big issue there in TikTok was how much should the court take into account the incidental effect on American speech on those Americans who chose to use TikTok. And in my view, it's a prudential judgment much more than a constitutional judgment, one reserved to the legislature. And then similarly with Paxton, again, nobody says that these kids have a right to see porn. In fact, all 9 justices said not only is there not a right to see porn, there's a compelling governmental interest in keeping them from seeing porn. And so then the question becomes the incidental burden on adults. How much does that incidental burden matter? And I think the big disagreement that I had with FIRE on both that and TikTok was I just didn't see the incidental burden as really even being that big a burden at all. Oh gosh, I have to go to Instagram. Is not a giant burden. Or I have to show ID like the way I show ID I was going to say the way I show ID when I go to a strip club. I do not do that. The way people show ID when they go to a strip club. That's not a burden. And so I think that's the difference. And I think there's an interesting difference in a lot of First Amendment advocates between those who kind of believe that the present state of the law is pretty good and those who would say, it could be a little better. It could be a little better. And I'm in the it could be a little better camp, definitely when it comes to campaign finance. And I think some other folks are it could be a little better when it comes to, say, pornography or social media, et cetera. But I'm by and large in the camp that the present state of the case law is pretty solid.
I will make a prediction that the tiers of scrutiny fall in the First Amendment in the next 5 years. But I will make another prediction, where you have seen the justices, and particularly the ones that are most likely to be in the majority, talk about how to think about precedents that were not decided on originalist grounds, that in and of itself is not a reason to overturn the precedent just because it would be decided differently today as an originalist or under text history and tradition, that those reliance interests still matter, the underlying sort of vibes theory. So I predict that tiers of scrutiny fall in the First Amendment context. I also predict that a lot of those precedents are upheld. Okay, Molly, I know we're standing between them and dinner, but one more.
Hi, I wanted your guys' opinions on the recent Supreme Court decision that came down with the Mahmoud family that basically requires school districts to have opt-out options for parents who believe their religious rights are being violated because of access to books that have LGBTQ instruction. Specifically, there are concerns that this would infringe on other parental rights and freedom of speech and freedom of inquiry of other kids, because school districts would then opt to not even think about offering that instruction because it would just be such a large burden on the school districts.
Yeah, I mean, we were actually going to talk about this in a future episode. But a really interesting way to think about the tension between the Kennedy v. Bremerton case about the prayer on the 50-yard line and the Mahmoud case is what is coercive for students and how do we weigh that? In the Kennedy case, of course, you had the three dissenters saying that prayer in football games would be coercive on students. They would feel the need to participate because that's the power that teachers have when they are saying, this is good, and you look up to that teacher, then you are coerced into saying this is good too. But the same three dissenters in the Mahmoud case are saying, well, teachers reading this book and saying this is good, even though it's against your religious practices at home, is not coercive. There's differences in age, high school to elementary school, but you'd think that would cut the opposite way. There's differences in topics, certainly, but they both deal with coercion in religion. And I wish they had addressed that.
I believe the Mahmoud case was right outcome, wrong reasoning. And by right outcome, I mean under the facts of the case, what you saw in the Maryland School Board was outright religious discrimination. In other words, it was granting some religious objections and denying others. So, for example, a religious objection involving a visual image of Muhammad, for example. And so then you're getting the state and the business of picking and choosing between competing religious viewpoints as to which ones it's going to honor with an opt-out and which ones it won't. So to me, I wonder if you could have actually even maybe gotten to 7-2 on this case if it was very narrow that once you grant opt-outs, you can't opt out for favored viewpoints and deny opt-outs to disfavored viewpoints.
Whereas the court in this case said you must offer opt-outs. That's what was a little bit surprising, I think, to both of us.
It seemed to, and you correct me, Sarah, if you think I'm overreading the case, but it seemed to me that it created, in essence, a freestanding free exercise right amongst parents to force school districts to provide curriculum that does not violate their religious beliefs when their child is in school. And that is an extremely difficult standard to uphold. That's extremely difficult because especially the way in which, as American politics has become more contentious, what I've started to see is people are pulling more and more things into their religion that are often been traditionally thought of as mainly political. And so there seems to be a kind of a thought process that goes something like this. I don't like this, and I'm Christian. Therefore, if you're exposing this to me, then you are violating my rights as a Christian. But one does not automatically flow into the other. So, for example, I don't like Duke basketball, and I'm a Christian. Does that mean that Christians can't like Duke basketball? Well, yeah, I'm sorry, wrong example. Duke basketball is evil, but
She is a Duke student. What are the chances? It's too good.
That is hilarious. Okay, that is hilarious. But anyway, it's only because of pain that was inflicted on me before you were born in the year 1992 by Christian Leitner. But anyway, so it is not the case that if I don't like something and I belong to a particular faith, that therefore my dislike is inherently, inextricably intertwined with my religious freedom. And this is what I fear is going to happen partly as a result of this. And so I think the reasoning was way overbroad, but the precise outcome that the school should have given the opt-out was correct.
Can I tell you, though, on the flip side historically, so weirdly, I wrote my law school note on 1988 fee shifting in First Amendment cases involving schools and religious practice. What was happening was the reverse of what you're talking about. And I think, unfortunately, in a lot of our politics, and perhaps law as well, we're just seeing pendulum swings, that one side took the pendulum up too far, and now the other side wants to swing the pendulum to sort of show them what it feels like. And what was happening in certainly like the 90s and early aughts, if a school was allowing any sort of religious practice, there were a lot of impact litigation groups on the left that were then bringing 1983 lawsuits against those schools. And if you win a 1983 lawsuit, meaning that the school is found to have violated your constitutional rights, there's 1988 fee shifting provisions, where then they also have to pay for your attorney's fees for bringing the case. There was then a huge incentive that if the ACLU sent you a letter, that you would stop whatever the practice was, even if it was your student's religious expression, and it would have been totally constitutional, because the risk is that maybe you're wrong that it's constitutional, or a judge finds that it's so, and now you're going to be out a huge amount of money. So schools were incredibly unprotective of their students' free expression and religious liberties within the school context because of those pretty perverse incentives. And I think you're seeing the pendulum swing to some extent. And history's kind of important to remember on that front. It doesn't make it right, but I think to understand this, you have to understand that.
Let me just say something for the free speech, the fees in successful free speech cases. That also helped me make a living for a lot of years. Although I will say, what thing was so unfortunate, Sarah, was I spent all these years litigating free speech cases, working for nonprofits, where when we won the fee award, I didn't get it. It went back to the nonprofit. Otherwise, I'd be rolling up here in my free speech Lamborghini, and it'd be amazing.
You certainly surely saw, though I'm sure you were never doing it, but using those fee shifting provisions to bully organizations.
Oh, for sure. I mean, that was the source of an awful lot of speech suppression, as you accurately say, was fear of lawsuits. And then that led to an entire strand of case law around, does the fear of an establishment clause case or a fear of an establishment clause violation provide a sufficient justification for a free speech or free exercise violation?
Yeah, and then of course these schools get pressed between both. Thank you, FIRE, so much for hosting us. Thank you, National Constitution Center, and to all you students, go out there and fight the fight.